There are parents who are enjoying the fame and the blessing of their children more than the children who have worked for it. You understand? So we plead to your conscience and also to your Christian morals that these are children. Help them to become great in society. Don't abandon them. They didn't come up with this decision of yours to go your separate ways. But the two of you brought them into this world together.
Welcome to Legal Agenda. My name is Matoda Boatinate, and we are still continuing our discussion on marriage, divorce, custody of children, and property acquisition, and how it is shared when there is divorce. I still have my guest in the studio, Reverend John Cato from SEM, and lawyer Sena Hoto, a private legal practitioner, to help me discuss this important topic. So, lawyer,
Yes.
with regards to custody of children, what are some of the things the court will look out for before a child is given to a particular person after the divorce or after the court has finally dissolved the marriage? What does the court look out for?
Okay. So thank you so much for having me in your studios once again. Like I always say, it's always a pleasure. You know, when it comes to custody of children, it's a very, very sensitive matter. And so if you are aware of the proceedings of divorce and custody matters in court, almost all our courts have it either in the chambers of the judge or nobody else has to be present.
Okay.
Because we look ultimately at just one thing, which you would find in the Children's Act of Ghana, that the best and paramount interest of the child, that is the sole consideration for determining who has custody or not. And so the court can look at an application before it and then say that, look, the father and then the mother are not the best people to take care of the child. It is not in the best interest of the child to stay with these two, but that child should be with a relative or a court-appointed person who will take care of that child or go into the system.
Okay.
You understand? So the first and most important thing is the best interest of the child.
Okay.
Now, when the court determines that a particular approach is in the best interest of the child, now it goes ahead to look at some list or guidelines to decide who gets to have custody and who doesn't get to have custody.
Okay.
Now the child in question, you know, which is a subject or is a subject of this proceedings, the court looks at their gender.
Okay.
Is that child a male or a female? Typically, the law is that the child, especially a female child, will not be awarded to their father.
Okay.
The policy rationale, which I understand, is that the men naturally, we wake up and we're gone. We're busy, we won't have time to take care of the child. And a female child has certain special needs more than the male child. You know, bathing, taking care of them, and ensuring that they have that instincts that they will grow up with to become responsible, you know, females and mothers, you know, of the next generation.
Okay.
The policy is that the male will not be able to do that. I find that discriminatory anyway, and I think that modern fathers are doing far, far, far better. Modern fathers were stretching the boundaries of you know, being there for our children, amongst others. So that is one of the things you look out for. Then you also consider the fact that when you have more than one child, and one is a female and the other is a male, or they are all males or all females, you will typically hear any of the parties saying that, let the boy come be with his father and then the girl child be with the mother at different places. The court naturally abhors such processes, because we don't want children to be separated from each other. They must grow together as siblings. And then that has a certain effect on the child. Don't forget that a child today is an adult and a future leader of the country tomorrow. And so when we mess up their upbringing and give them a certain stereotypical kind of growth and ideology and all of that, it affects the kind of society we're going to have. And so even though it is something that the two of you did, in the crack of dawn, and then a human being has been born, the state is interested in even how that child is brought up. So that's why even when you're not married and you treat the child in a certain way, the state can step in and take that child away from you. Because ordinarily, the child belongs to the state. They have just given you the leeway to take care of that child.
Well, that is the situation, but I don't know whether it's respected enough. I mean, we have a lot of children walking on the streets, with nobody to take care of them. So that is highly debatable, what you say.
It is, because nobody has. It is very likely that we all see it, and then we drive past, hoping and thinking that somebody else will come and make a formal complaint. And so if you want to test whether it's just law or it's mere puffery, make a formal complaint at the appropriate cortex, and then report that there is a child here who is a danger, or the place where you find the child is a danger to that child, and see if the child will not be rescued. The child will be, because that's what happens. Yes, there are a few lapses in the system. It may not be as fast as in other jurisdictions. It may be slower. It may not be as swift or smooth as it is, but it happens. It happens. So those are some of the two things the court looks at. Again, the court looks out for the upkeep of the child. Who the child gives custody to should not be based on who has more money. So, for example, you're married with your partner, and then you come to the conclusion that you're divorcing, and you know that the wife wasn't working and she came from a humble background. When the marriage is dissolved and she has nowhere else to go, and she has to go to the village in Soviet Mando or in Jamestown or any place of the sort, that child may struggle because they are not used to that kind of place. They are not used to those kind of facilities. They are used to a certain kind of lifestyle. The court has the power to order the other person that can afford it to pay for a place for the child, and it's typically for the child, but I mean the child alone cannot go and stay there. So for the mother and the child, and order that the other parent to make what we call maintenance towards the upkeep of the child. So we say that poverty is not an excuse to obtain custody. Again, the court also looks at the kind of lifestyle the children are used to. So you were living with a child at East Legon, or you were living with a child at Cantonment, and there's divorce, and because for some reason the child has to move to, so you live in Cantonment, the child has to move to Achimota, or Soweto or Dansoman, or even Adringan or Trasako, anywhere else you put it. The court looks at where the child will have the kind of lifestyle they are used to. And so if one party, has the means to be able to afford that kind of lifestyle, that the children are used to, the court will compel them or order them on an application by the other party to provide that kind of lifestyle for that child. So these are some of the things that the court looks out for.
Okay.
And then also the court also has what we call the inherent jurisdiction to do justice. And so where the court finds that the child is being abused, maltreated, malhandled or manhandled by a particular parent, the court has the power to grant custody to the other parent who, will pretty much take care of the child and not abuse them, compared to the one who may be making the application but has a demonstrable history of violence towards that child.
Okay, so the point you mentioned, I think I didn't hear you talk about age. Is age not a determining factor?
So age is also one of the determining factor when deciding on the custody of a child.
Okay.
But it is more applicable to when you're doing adoption proceedings or those kind of proceedings. But when you are going to give custody, the only time age is important is that, for example, a child is above 12. At that point, the court presumes that they can form an opinion.
Sure.
So they know who
they
want to be with. And so the court will invite those children and talk to them.
Okay.
Sometimes most times the courts are very, very friendly to children. You'll be amazed. Sometimes you go to some judges' chambers and they have candies, toffees and all of that. Yeah. And then they give just so that the child will feel relaxed. And when there is a potential abuser, either of the parents, the court will let them move out.
Okay.
And then sometimes the judge will just talk to the child alone.
Okay. Because
the child may feel intimidated or afraid that if I don't say this and I go home, my mom or my dad will beat me. So if it is in the best interest of the child, we can ask you to step aside, and then that is done. Okay. Now back to the age factor thing. Now the child is consulted or spoken to and asked. Remember, even an expert opinion, an opinion from an expert witness or an expert opinion is not binding on the court. Okay. It has a persuasive, effect on the court. And so when the child says, I want to stay with mommy or I want to stay with daddy, the court doesn't just take that hook, line, and sinker and say, okay, the child says he wants to stay with you, so you carry this child and then you don't get it. But it looks at all the factors in totality and comes to one conclusion. Okay. What is the best interest of that child? Okay. So once that conclusion is reached, based on all these factors, amongst others, then the court can decide that a child goes to party A or party B. Okay. The very nitty-gritties of it is dependent on a case-by-case basis. There are certain situations or circumstances where, yes, we would say that if it's a female child or it's a young child, the custody is usually almost always given to the female and not the male for some of these reasons. But if the male can demonstrate what we call impeaching the character of the female or the wife, or by the time they get to distribution of custody, the divorce would have been granted itself. It's just the custody. Those are ancillary reliefs that have been discussed. So the ex-wife, if the ex-husband can demonstrate to the court that the ex-wife has certain traits, for example, they occasionally get visited by the ghost upstairs. So they get to that point where they are not lucid anymore. Okay. So they have those moments in between lucid and then that kind of situation. And then they can also demonstrate that there's been instances where, for example, the mother got so angry they poured hot water on the child, or they held them, threw them in the gutter, and so, but for their timely intervention, those children would have been badly hurt or would have even died. If you can demonstrate that to the court and base that as a grounds, the court can make can grant the custody in the favor of the father,
Okay.
but may just put in place certain factors to ensure that while the child is with the father, there is some form of touch of a female, either the parent or there's someone else who will assist, or if their father can demonstrate that I don't need anybody else, I am able to, because of factor A, B, C, D. Remember, money is not a factor that the court really considers, though it's important. It's not really one of the key deciding factors. If you can convince the court, then the custody of that child will be made to you.
Okay. So, Reverend, we've had situations. So, what lawyer said has to do with cases which are referred to the court. But there are so many scenarios where divorce do occur, but it doesn't go through the court processes, especially people who go through the customary marriages. And so, I want to know if the church has some form of interventions to solve some of these things, especially with regards to the custody of children and how the children are handled by the couple after the divorce, the messy divorce.
Yes, thank you. I think we follow through with the same procedure as a lawyer has also mentioned. Because most of the time, if it comes to the church and the church has to deal with it, not one person deals with it.
Okay.
There is a committee of counselors, and in our counseling units in the church, we have every professional and every expert that connects to marriage.
Okay.
Like as I said earlier, we have doctors, lawyers, psychologists, and all those. So when it comes to this, the law equally applies.
Okay.
When it is the church handling it. Okay. And we follow, especially the children interest.
All right.
Because they didn't ask you to marry the first place. And they are not asking you to divorce.
Okay.
So they cannot suffer for your decisions.
Exactly.
You understand? And as lawyer said, you are just custodians of their lives.
Exactly.
Either on behalf of God or the state. You are just stewards, taking care of them and leading them in the way that they should go, that when they grow, they will not depart from it. So you give them all the biblical examples. You make all the right choices for them. School to attend, courses to pursue, places to go, the kind of language and attitude and behavior, whatever. You help them to form it and become what God has ordained for them to be. So if you decide to go your separate ways, they shouldn't suffer for it. So we also look at the same landmarks. And the paramount is that they can be taken care of. Okay. So who can take care of them? Who can meet their emotional needs? Because like lawyer said, the female among the children, they have their cycles. Can the man give them the necessary support for them to understand the cycle and how to handle themselves?
But Reverend, not to cut you short on what you are saying, you know, when the court makes an order, it's binding.
Yeah.
But the church, you don't have such powers. So how do you enforce some of these laws that you make, some of these orders that you make? How do you enforce it on them, since it's not really binding?
Yes, we are not binding them to it, but we appeal to your conscience and the understanding that these children are connected to you. When they become great in society, it's connected to you. There are parents who are enjoying the fame and the blessing of their children more than the children who have worked for it. You understand? So we plead to your conscience and also to your Christian morals that these are children. Help them to become great in society. Don't abandon them. They didn't come up with this decision of yours to go your separate ways. But the two of you brought them into this world together by the help of God or whatever it is. But help them to be responsible. Help them to attain that mark of their calling. Help them to grow well. So knowing your strength, we appeal to you. If one is good at nurturing them, giving them tutelage, instructing them and leading them, let it be so. And if one is stronger at providing and giving the support, let it be so. So let it be at the interest of the children. So you agree. But we will not deny anyone of access to the children, because sometimes as human beings also, if the woman is the stronger one in bringing up the children because of discipline, character formation, and all those things, and you give the children to the woman tends to block the man from coming close to the children. Meanwhile, when it comes to taking the upkeep money, they demand it and they take it. You see, so corporately, go your separate ways, but come together to bring up the children to the point where they can take care of themselves. So we encourage them, but we will not force it on one person. We will not say the woman should take custody and the man should not go there, or the man should have them at certain points. The two of you should agree. We believe once you are Christians, and you have the children interest at heart, let it be so. So we will encourage you and admonish you. But if we see, if one is trying to be a bit stubborn in adhering to whatever decision has been taken, whatever compromise we have come to for the good of the children, then we will tell you to please go to court and let the court bind you. But we think that it shouldn't get there where you are forced to do things for the interest of the children. You should just do it willingly. Doing it knowing that tomorrow, if they become great in society, it still points to you. But if you do things to them that hurts the children will disconnect from you.
Exactly.
They will disconnect. And we don't want you to lose that privilege and that opportunity of having great children, having responsible children, having blessed children.
And which affect the society at the long run.
So we will do our best to encourage you to do as will be required of you to do for the children.
Okay, so we'll just go for a very short break. We'll be right back.
Every advert is FDA approved.
Welcome back to Legal Agenda. We've been discussing dissolution of marriage, and we also want to touch on how your property or properties that have been acquired in a marriage will be shared amongst the couple once the marriage has been dissolved. So lawyer, can you touch on how properties are shared when eventually there is dissolution of the marriage? Especially, I want you to touch on properties which one acquired before the marriage. A lot of, let's say the man might have a house before marrying the woman. So that's a property that has been acquired before the marriage. And in the course of the marriage, let's say a family member, so I'm dividing it into three. In the course of the marriage, let's say the father dies and wills a property to the man in the course of the marriage. So that is also a separate property. Then in the course of the marriage, the couple acquires property jointly. So how should these three types of properties be handled during the dissolution of marriage?
All right. Thank you. So when you reach the point where the court has dissolved the marriage, has dealt with the custody aspect, and is now dealing with the property aspects, there are things that the court considers. Okay. Now, when it comes to dissolution of properties, there are some properties that are not, distributable, for lack of a better word. It doesn't form part of spousal property to even be distributed. One is properties that you acquire before marriage. So you look at somebody and you think he's rich, and so you want to go and marry him so that you get part of his properties. You marry him for, you want to watch the law, and you've listened to Lawyer Senna, and you know that you cannot bring you can't bring a divorce, within 2 years. So you wait immediately after 2 years, and then you say, I want a divorce so that you can split the property. It may work in other jurisdictions like in the United States, but here in Ghana, you cannot get anything from what the person acquired before. 2, any gift that either of you receive does not form part of spousal property. And so somebody dashes you a 4-bedroom duplex in a very nice place in Pediase. Whilst you are married, it doesn't form part of the spousal property upon dissolution of the marriage. Now you inherit properties as well from anybody. Upon dissolution of the marriage, those ones are untouchable. It doesn't form part of the spousal property. So the question is, what forms part of spousal property? Before I even touch on that, there's another part that also doesn't form part of spousal property, which the Supreme Court has recently explained from the latter part of last year, let's say early part of last year, and again throughout the year, and then the latter part of this year, in a mountain of cases. And that is that if a person solely acquires a property under their constitutionally guaranteed rights to own property, if they acquire that property solely by themselves without your assistance or help or anything of a sort, they are entitled to own that property separately from the marriage and or from you. And so those properties do not also form a subject of the properties for dissolution. Now the key thing is, what then constitutes what can be dissolved, what can be distributed upon dissolution of a marriage? Any property that is acquired during the pendency of the marriage, which is not what I have already mentioned, is property that can be distributed during marriage. The question is, how does the court determine who gets what and what percentage does someone get? The general position is that we are assuming that you all own it equally. That's the general position.
All right.
So it's a 50-50 thing. However, it's a presumption and it is not cast in stone. You must show or demonstrate to the court that you contributed towards the acquisition of the property. So I always say that your husband is building a property at Nanakrom or East Legon Hills, and he's at the roofing level, and every day you are, my husband is doing some property there. Cook food, give to the people that are cooking, that are constructing. Do something that you can demonstrate that you have contributed. Support in buying the wiring, the roofing, and all of that. Demonstrate that you have done a contribution towards the acquisition of that property, and that will help in what percentage you get. However, the Supreme Court, in its wisdom again, has told us that contribution need not be financial. So you don't necessarily have to say, I contributed because I paid X amount of money. Conjugal duties is a form of contribution. Because you gave him peace of mind by taking care of the children. So if you look at there was a case of a footballer who the house at East Legon, and I readily can remember that case, not the Samoajan one. Odate Lamte situation, where the court had to look at the contribution. The arguments Mrs. Lamte at the time was making was that, look, when he was a footballer in Germany, I even went there, I was driving him. At the time, he didn't know how to drive. At the time, I was taking care of the children. So all those taking care of the children, we could have hired a nanny. How much would a nanny be taking? And I was there, I was cleaning the house. We could have hired a cleaner. I was cooking, we could have hired a cook. So all of that gave the man the peace of mind to be able to go out there knowing that he doesn't have to close and come back at 5 p.m. to come and change diapers because I'm there. And those are the contributions that allowed him to be able to make that acquisition of the property. And so that is your contribution. So if you can demonstrate some of these things, then you can convince the court or move the mind of the court to say that, look, with all this contribution, in fact, I think I deserve 60% and the man deserves 40%.
Okay.
And if the court is minded by your arguments, they will grant it. If they go for an appeal anywhere else, and your arguments are strong enough with the requisite evidence provided, it will still hold the test. So that's one of the ways that the court goes through in determining and distributing who gets what.
Okay, I think that the next time we meet on this platform, I'm going to ask you to explain why, a number of people, especially the ladies, fall foul to this. They purchase property, let's say land, and they write Mr. and Mrs., let's say Mr. and Mrs. Owusu, Mr. and Mrs. Ej, without bringing the lady's name on the document. So the Mrs.,
who is the Mrs.?
Who is the Mrs.? When there is divorce, or eventually when the couple are no more together, and the man goes ahead to marry another lady, then the property now belongs to the now Mrs.
Not really.
Not really.
Not really.
Okay.
Not really. The question is, when was the property dated?
Acquired.
Okay.
When was it acquired? Who was the Mr. and Mrs. at the time?
Okay.
You understand? So this is not a subject of wills.
Okay.
This is a subject of divorce. And then the parties that are known are Mr. and Mrs. When it comes to the concept of interpretation of deeds and statutes among those things, you must read the document as a whole.
Okay.
So if you look at the land document, it is not only the indenture that has your name. All those other places are there. And then there's a place you sign. So granted your name is even gone. Whose signature is that? So it's not just about putting Mr. and Mrs. this on. In any case, you can have a property. I used to be a strong advocate for that. Now I don't quite subscribe to that, but it is still not wrong. Your husband buys a property and puts it in only his name. It doesn't matter. When it is time for distribution of property, it will be shared. So you don't just go ahead and say, oh, I'm trying to be smart, and then I'm just buying the property, some secret property somewhere, and I'll put, even if you go for a loan at the bank, before you use a property, the bank is supposed to come for consent from your spouse. Because there's a presumption that it's a spousal property.
Yeah.
You understand? So some of these things people don't know, but that's how it is.
All right. Thank you so much. And Reverend, final words.
The church follows the same procedure because when it gets to that point, people become very emotional and sometimes very greedy. So in order for the church not to be blamed in anything, we will wish couple will be fair to each other. And this one we are talking at both sides because sometimes the women also do very well in acquiring properties during marriage and things like that because they will have the opportunities and the privileges due to the work they do and all that things. So we hope and pray and ask, request that the couple be fair. Everybody goes happy. But when we see it's becoming difficult, people are becoming selfish and very emotional. Some people can dramatize the emotions and whatever it is. Go to court, let the court decide per the law so that everybody is bounded by
the church.
The church is out. Yes.
Wow, thank you so much for sharing your ideas to us regarding marriage, divorce, and custody of children and how properties should be shared. We've learned enough. We've learned a lot of things. Thank you, Lawyer Sena Hoto, and thank you, Reverend John Kato. I don't know if I got the name right.
Yes, correct.
From SEM. And this has been Legal Agenda with your host, Matilda Boate Nate. Until we come your way again next week, we say stay blessed. Thank you.